Hello, my name is Charles Lincoln. I'll be giving a presentation on comparing U.S. tax jurisprudence and the OECD approach to risk allocation. No, the both approaches, yeah, to risk allocation. In the post-BEPS era of transfer pricing, so the modern era, so to speak. Just as a side note, before going on, Action 9 covers the arm's length principle of risk allocation of intercompany transactions. The OECD considers that risk is an important part of pricing a transaction, but because risks can be contractually allocated easily, the OECD considers that multinational enterprises can pursue tax planning strategies based on contractual risk allocations, sometimes without any changes to the business operations. Action 9 addresses this in the Chapter 1 of the OECD transfer pricing guidelines. According to the revision, allocation of risk should be based on the functionality of the decision making. We'll get into that in just a second. Management and control of the risk rather than merely contractual reallocation of the parties. The OECD proposes a six-step approach to identification of contractual assumptions, functional analysis, allocation of pricing risks, and each step is very detailed in the OECD Action 9. So when companies are conducting business, they face many risks, but for transfer pricing purposes, those risks should be considered. The only risks that should be considered are those that relevantly affect the expected profits. Both externally and internally, risks are driven, they're equally relevant. So you look at the external and internal. However, risk should be identified with specificity and not vaguely described. So in the past, transfer pricing analyses were merely comprised of a list of unspecified tax-related parties may face in the transaction, and the transfer pricing guidelines require that only risks be included in the analysis that have true impact on the profitability of the business. This will require the multinational to perform sensitive analysis, such as tornado diagramming, Monte Carlo simulations, things like that, and supported by financial modeling and scenario analysis of risk. Those risks, for example, on top of a tornado diagram will be included to have functional analysis, while risk at the bottom have little impact on financial results. But for each risk that has to be identified, who makes the decisions on whether or within the restrictions are assumed and how these risks or their financial effects can be managed, controlled, who performs the management and control for which the party has the financial capacity to assume the risk. The mere existence of generally formulated risk policies does not shift allocation of risk and return to the policy maker. In step 2, you analyze the contractual assumptions of the risk. The transfer pricing guidelines acknowledge the conventional wisdom that assumption of risk and expected return are positively correlated, and that contractual terms may thus allocate risk and return related parties in which one assumes risk against a higher but more unstable expected return, while others lay off risks accepting lower but more stable returns. The contractual terms between related parties should clearly confirm that risk allocation between them, but the transfer pricing guidelines consider actual behavior of related parties more important. Also, the parties should be able to provide evidence that the contractual terms are actually result in outcomes in accordance with correlation between risk and return. Multinationals support more effort. Practically speaking, the implication of this is that multinationals should put more effort in providing evidence to the tax administrations that risk allocation be between transacting enterprises expected, the lower result in lower but more stable returns for the one laying off the risk, and in higher but more volatile returns to the party assuming the risk. Financial scenario analysis techniques supported by Monte Carlo simulations may provide such evidence. Example of a simulation performed to test the risk allocation between a marketing and manufacturing company. The red graph shows that the risk distribution of the marketing company returns after allocation of part of the market risks to the sales company, where the blue graph shows a distribution of returns if no such allocation had taken place. Indeed, the graph demonstrates that the allocation results in marketing being exposed to less risk in exchange for less expected return. So anyway, this is just a general information about the risks. let's get straight into the diagram. Traditionally, you have a situation, or not even traditionally, this is just the basic scenario. Individual controls assets. They can be of any nature, such as manufacturing capabilities or even a solo practice of some sort. And who's going to be taxed? That's the number one question. The individual will be taxed. But let's say we change the scenario and we create an LLC or some sort of company around the assets. Who's going to be taxed in that scenario? Well, it's going to be the company that's taxed. But let's say we change that scenario and we're entering, higher stages of more complex capitalism, where you have a company managing a company. You have assets managed by another company. You have an asset manager managing another company. Traditionally, the assets will be taxed, and now under the OECD, under the six-step approach, the asset management company, where the smiley face is what's going to be taxed. This is very interesting because the U.S. tax courts have, even in the post-BEPS era, relied on the contractual reallocation of, or contractual allocation of lists. They don't buy into this concept of where risk is according to the OECD. But rather they stay true to the concept and very much guided by the policy of stare decisis, that the way we've decided things in the past must be, unless the legislature changes the rules, must be the rules that we use today. And that is that. Now, the problem is in step 5, where step 5 really disregards steps 1 through 4, because it says that the contracts will only be followed if the financial capacity to assume the risk is present. Otherwise, the intercompany transactions will be disregarded. The problem is we're looking at the main problem lies in step 3. OECD indicates the arm's length risk allocation to determine which contracting party controls the risk. Paragraph 1.65 defines control over risk as the capability to make decisions and the capability to make decisions and how to respond to risks. So that's the first definition over control over risk. Now, assumption of risk is further defined in one paragraph, where the party assuming the risk has the financial capacity to assume the risk. So both questions as to who contracts the risk or has the financial capacity to control the risk leads to functionality analysis. This is the disguise that the risk analysis, the company should allocate risks on the parties having functionality. Therefore, it's relevant who has agreed. It's not relevant what they've agreed to, but rather what they should have agreed to. Nowhere is the capitalization of finance-related company relevant, but rather the capitalization of the company had assumed to have access to based on its functionality. The OECD defines financial capacity to assume risk as access to funding, take on risk, and lay off the risk. Thus, contractual allocations will only be followed if the functionality test proves the contracts. In other words, contractual allocation will be followed only if the contracts allocates risk to the OECD wants the risk to be allocated to. So in summary, the OECD, in a disguised way, says that contracts are no longer relevant. This was probably based off a compromise that was made internally at the OECD, since the United States provides most of the funding for the OECD, and it's no longer relevant. The U.S. tax court's jurisprudence still look at the contracts first. There will be a fissure where the U.S. will tax where it traditionally is taxed, according to the common law rule that's been upheld for thousands of years, going back to the Anglo-Saxon courts, that like cases should be decided likewise, and the OECD is acting as a sort of legislature, although this hasn't been passed yet, and perhaps not so, but it's proposing that these rules be changed. And the main difference is that the U.S. courts, despite BEPS, will continue to analyze the intercompany agreements first.